What a trial that was, the trial of Michael Peterson. Welcome back, folks. We're taking a look at some of the trials that are coming up here in 2022 on your front row seat to justice. And right now I want to look at the first one on our docket, set to begin as soon as the new year starts. It's a case involving a guy named Theodore Edgcomb facing first-degree reckless homicide charges. His defense is self-defense in what happened when he shot and killed Jason Cleereman. Stephanie Haynes from our affiliate WTMJ in Milwaukee has the story.
This is a clear case of self-defense, and we look forward to and maintain confidence in our judicial system to establish the same.
Family, friends, activists, and attorneys spoke out, including Edgcomb's mother.
My son is a very humble person, and anybody that knows him knows that this is not his character.
According to the criminal complaint, in September of last year, Edgcomb was riding a bike when he came upon 54-year-old Jason Cleereman and his wife in their car near Humboldt and Brady Streets. Prosecutors believe that's when there was some sort of verbal altercation and Edgcomb punched Cleereman. Edgcomb's attorneys say this new surveillance video shows the Cleeremans followed Edgcomb onto the Holton Street Bridge and shows Cleereman got out of the car and approached Edgcomb in the moments before the shooting. Shortly after the shooting, TMJ4 News spoke to Cleereman's wife.
And my husband got out because he just talked to the man, and the guy waited. I'm just standing there waiting. And as my husband got real close, I saw him pull out a gun, and my husband never saw it because he was close and shot him point blank in the head. And I saw my husband drop down.
Edgcomb's attorneys are trying to retain the same self-defense expert the attorneys for Kyle Rittenhouse used at trial.
Theodore Edgcomb deserves the same right that Kyle Rittenhouse got.
Okay, the defense is the same as Kyle Rittenhouse, but are the facts similar? I mean, is there a valid self-defense claim here? And when you look at this case, there's some more allegations by prosecutors here. Now, you're going to see that video, and you saw the video of the car that was driven by Jason Cleereman's wife. He's in the passenger seat, so you see it as it makes the turn after Theodore Edgcomb made the turn around the corner. What you don't see and what you're going to hear testimony about is what allegedly happened before all of this. Before all of this, the allegation by prosecutors is that Edgcomb approached that vehicle after there was some sort of a verbal altercation and punched Cleereman in the face and then rode away on his bike. And then that's where the video picks up what happens next. Okay, now whether or not Jason Cleereman's wife is following him or they're just going in the same direction, we'll see what the evidence shows during the course of the trial. Of course, the allegation from the defense is going to be that, yeah, they followed him. They pursued him. They chased him. And then he got out of the car and pursued him more. You see it on the videotape, ladies and gentlemen. And that's why Theodore Edgcomb had to defend himself. Now, the other fact here that is different than the Rittenhouse case is Kyle Rittenhouse, immediately after the shootings, puts his hands up, approaches police. They wave him off, but then he turns himself into police later in the early morning hours of that day. Here, this guy doesn't turn himself in. I mean, he takes off, never turns himself in, never calls police, is actually apprehended and caught 6 months later down the road. So is there a potential valid self-defense claim here? And if so, what are some of the obstacles that this defendant has? What are some of the obstacles that the prosecution has in all of this? I mean, is this going to play out like the Rittenhouse case, or is it much, much different? We're in the same state. They want to use the same expert. We'll see how that plays out. Let's bring back in our think tank, Renee Hill, Carmen Rowe, Jennifer Brandt back with us. Carmen, I'll begin with you. How do you see this? Because I've been talking about this all week, and a lot of our experts seeing it differently.
Yeah, Vinny, this case is complicated, but it is like Rittenhouse to the extent that everybody who watched the Rittenhouse video thought they knew what happened, whether it was on one side or the other. Ultimately, it came down to testimony at trial, which changed things for the other half of the group. Now, this case is going to be the same. I understand that this victim had a knife folded in his pocket. Did the defendant know about that? Was that something he considered at the time? But ultimately, I think this defense is going to be difficult because I don't see any deadly force or serious bodily injury being exerted on this individual. And so from that perspective, the defense is going to have to show that his actions in shooting point blank and killing this man was based on his reasonable belief that serious bodily injury or death was going to result. And even on the video, we don't see that. So this is going to come down to testimony at trial about all the things we don't see on this video.
And
Yeah,
Vinny,
and
I
you-
think
you
that,
have to
that
think
the
about
most,
the,
I think, well, I was going to say, Renee, that I think
Go
one
ahead,
of the
go
most
ahead.
troubling things for me is that, hearing about this shot at the point blank at the head, the shot at the head. I mean, to me, that doesn't sound like self-defense, because if you're defending yourself, you would just shoot anywhere. This seems, that's the hardest fact for me to swallow, I think, in this one, in terms of a self-defense.
Well,
I
I
just
think you're
don't
gonna
see that
hear-
happening.
I think you're going to hear about the racial epithets that were allegedly being thrown, right? That he was perhaps being threatened initially by them. And then the testimony will have to come from this defendant, from Mr. Edgcomb, that, again, like Carmen said, it's what he perceived at the time. And he may testify that, listen, when this guy got out of the car, where were his hands? What was he saying? We don't know. And this is what he's going to have to testify to, or it will have to be elicited, that he was in reasonable fear of being killed because he didn't know what this man had. And maybe the man was saying things to him like, yeah, I'm going to kill you. And he pulled his gun out.
All right, Renee.
So
I mean, I hear you, and
don't
I
know.
agree with I agree with that. But the other part of it that's troubling is that where did he go for 6 months? If he was threatened,
Yeah, I
and
get that.
he felt
ran
like,
away.
he ran away, he disappeared. I mean, maybe he was afraid. I can understand that.
Absolutely.
We can think of a
And
lot of
that's
different
the
things.
problem here.
But 6 months down the road, and he knows that this guy
Well,
got
listen,
killed. I mean, if
the
it was
fact that
really
he ran
self-defense,
away-
why didn't he come forward and say,
you can
this is
have
what happened?
self-defense without, you can have self-defense and still run away. He was afraid, obviously.
I get it, but it's just
Yes,
from a juror's
absolutely.
perspective,
And
it's
from,
probably
from
troubling.
a juror's perspective as well. His attorneys, and I can see it already from the press conference that they're giving, his attorneys are going to be putting forth, look, this is a black man who killed a white man. He had every reason to be afraid and every reason to run away. Yes, it's consciousness of guilt, but it doesn't absolve the fact that if he acted in self-defense because he reasonably believed that he was going to be killed, that's how he behaved. And the fact that he ran away, that's something after the fact. And I think that that's what his defense team is going to argue.
Well, and something else to keep in mind for the viewers at home is that verbal provocation, no matter how ugly, no matter how inciting, no matter how racist, will not justify an assault of any kind. And so while that's coming up as an issue, it's kind of like the issue that we're talking about him fleeing. At the end of the day, if he was justified in shooting at the moment that he shot, it doesn't matter where he shot, it doesn't matter about the circumstances, except that he is justified, as a reasonable person would have been in those circumstances, to use deadly force. And if the law says that that's true, and he can get evidence forward that a jury would believe that a reasonable person would have acted the same way under those circumstances, he should be found not guilty based on self-defense. And again, it's going to come down to what we hear in the courtroom, what the testimony is, and of course, whether the jury believes that testimony.
One final issue here. One final issue. He's a convicted felon, not permitted to have a gun.
I say that he gets, if he puts forth a good self-defense claim, he's acquitted of the homicide and he goes down on the gun. I've had that happen. Specifically.
Well, that defendant had Renee Hill in the courtroom. We'll see if this defendant has someone of that caliber. May very well be, but we shall see.